will deliver a judgment. We have got nothing further to add. We are not going to make that request that we would like to like that reference. So we leave it to lordships to decide in accordance with law.
All right,
And my lord, so far as our argument is concerned, we have given one written argument first. Then on violation of Article 14, we supplemented it by a subsequent one. These are our twofold argument.
But of our own, we might say,
Yes, that's a different thing.
will not take your concession.
Yes.
Correct.
Yeah. Deeply okay.
All right, so at 2, we will be pronouncing the judgment.
Right.
We'll say it will come a day later. Or all right.
Deeply.
Adjournment request from item number 1 to 5. From item number 6 to 17, adjournment request.
May it please your lordship, with the consider the other side, I beg to mention item number 16 of today's daily list.
Adjournment slip has been circulated. July.
Lordship,
15 July.
Lordship, in view of the order dated 1/4/2026 and data bill number 7926, Lordship, item number 19 has become infructuous.
You are Mr.
And Gautam, Lord.
Mr. N. Gautam, learned advocate for the appellant, submits that in view of a judgment passed by this court in so and so. Give the
Data bill number 79/26 in dated 1/4/2026.
this appeal has become infructuous, dismissed as having become infructuous. Judgment की details ले लेना.
From item number 18 to 22, adjournment request.
Lordship, I'm very apologize, lordship. Item number 18, your lordship. I couldn't circulate because lordship, later in the evening, I came to know that the affidavit is not in record, your lordship.
You appear for whom?
I'm appealing for the respondent, your lordship.
Respond number?
All the respondent.
What is your name?
DJ Das, your lordship.
Mr. DJ Das, learned advocate for. Have you informed the other side?
Yes, lordship.
I'm for the petitioner.
Okay. Mr. DJ Das, learned advocate for the respondents, seeks adjournment in the matter. After having taken consent from the counsel for the petition, re-notify so and so date, your date.
Third June.
May I please your lordship, I beg to mention item 21 for adjournment. We have taken the consent of the other side. We will find affidavit.
Item number 21. As prayed for, you are for the petition.
Petitioner.
As prayed for on behalf of the appellant and agreed to by the land counsel for the respondent. The matter is adjourned to so and so date.
17 July.
May it please your lordships, when they consider the other side, I beg to mention item number 20 as well. For today's meeting.
20, all right, adjournment slip has been circulated.
Can I pray to early take your lordship in this?
Sometimes in June.
12 June.
Much obliged.
May please your lordship. Lordship, I have filed IA in PIL 52 of 25, lordship, for correction of cost title, lordship. I may be listed.
Where? Item number?
No, lordship.
Item number?
For listing, lordship.
Unlisted.
I'm praying for listing, lordship.
Listing today,
No,
after the court reopens.
immediately
Why do you have to mention it today? We'll see.
after Bihu vacation.
All right. Anytime in the next week. After 23rd.
Yes.
Um,
Any other request? Daily list for orders, item 1.
Wait, please, your lordship. Lordship, there's an office note dated 6/4/26, lordship. It says that the person has left. Now, lordship, my instruction is that this respondent number 13 and 14 had already retired from service.
How does it make a difference so far as serving them is concerned?
Lordship, we have taken the steps also, lordship.
You have taken the steps, but you'll have to take fresh steps
Lordship,
on the new address.
new address, lordship. In that case, we'll have to ascertain because the department will only know the.
We are giving you
character.
time
Lordship, please.
in view of the office note. Suggesting that respondents number 13 and 14 have left their present place of address, comma, fresh notices will have to be required. Fresh notices would be required to be sent to them. Let fresh notice to on response number 13 and 14 to be issued on steps being taken by the appellant within a period of 4 weeks, including furnishing of correct and present address, both modes returnable 8 weeks.
I'm so blessed.
17 July. Item 2.
So item 2, also here we have already complied with the direction of the Honorable Court of Justice. The petitioner has already been promoted and he has already joined his portfolio. This is the complaint order. I have flagged my data.
No. The who appears for respond number 3?
It three losses, I'm appearing your six.
Who appearing for respond number 3? What was this matter?
Matter regarding promotion to the postal headmaster of the petitioner. Their direction to promote their key promotion. And that we have already given him promotion. He has already joined his postal.
He has already joined.
I have given the joining letter also.
Withdraw this application. In view of the statement made on behalf of respond number 3, Mr. Borhuya, learned advocate for the petitioner, seeks permission to withdraw this application.
Yes, right.
Dismissed as withdrawn as become infractious.
I'm also appealing for other respondents also.
On behalf of respondents.
Item 3.
In view of the statement made by learned advocate on behalf of the respondents that the order has been complied with, Mr. Borhuya. Yes.
Lordship, in terms of the order dated 10/12/2025 by this honorable court, Lordship, we have been issued the probate certificate, Lordship. But a larger issue is kept open, and the last occasion.
Why has it come for orders?
The IA, Lordship.
Just a minute, will
Lordship.
So that probate certificate has been
It
granted.
has been granted.
What is
The
left?
larger question remain open, Lordship, by when they are going to implement it. On the last occasion, they took time
Let this
to.
matter come up for consideration under the heading of admission.
Lord.
We'll see. With the grant of probate certificate to the applicant, the IA. The IA, the present IA number 3261 of 2025 has become in practice. However, the larger issue still remains to be decided.
Lord.
For the aforesaid purpose. Make efforts to bring that forward. Let that matter remain where it is, because
Lordship.
the
Lordship.
division by judgment is over.
Lordship.
This IA has become in practice. Dismissed as become in practice.
Lordship.
Item 4.
Nobody appears on behalf of the applicants even today to press this application. It appears that the applicant / appellant has lost interest in the matter. Like, as well as the appeal is dismissed for non-prosecution.
Item 5.
It is for consideration of the application for the waiver. The present petitioner has liquidated the amount in the year 2022.
Have the respondents been served?
Yes.
All of them.
Filed an objection in both lead petition and review petition. The petitioner was not made a part. He is the main affected party.
All right, we condone the delay.
My lord, here, my lord.
Have you filed your response?
Yes, my lord. In the, my lord,
I think he has made out a case. Take it from the. Delay condoned, application allowed, appeal to be processed and listed preferably in July. Okay. You have heard so also. Okay, and take it from the.
Yes. Item 6.
It handles complete.
Late is your lordship. As regards respondent number, 4 streets has been taken through.
The report says that the service is complete.
Complete.
Then we place it in admission.
I think the order dated 23.
With all the respondents having been served, the matter is required to be adjudicated in the appropriate, if a matter is required to be adjudicated. Let the appeal be listed under the heading admission on
21/7.
Malad, because my tenure is up to August. So if it is.
July. You want in June.
Malad, prior to that, in May itself. it will-
May is not possible, June.
17th June.
Anyway, last of May. Will that satisfy you? May, last of May.
Last of
28th May. 2
28th May.
Item 7.
Lordship, respondents and enter appearance in the combination petition.
Yeah, what is it?
All served, I think.
Lordship.
8, 9.
Yes, Lordship, sir.
All served.
All have been served.
42 days.
Delay condoned, application allowed, you appeal to be processed and listed preferably as friends. Published.
7, 8.
9, 10.
9, 10.
also.
For 9, which are made a case. 9 and any case, lordship.
Now. Supplementary list orders item 23.
That's the effective. Yes.
First time I put a respondent number 2. Just a formal party.
He has been served, but giving one more opportunity. The respondents have been served, but except for respondent number 2, nobody has appeared today to contest this application. Giving one more opportunity to the respondent to contest the application for combination of delay of how many days?
600, my lord.
How many days? The application is matured to your data of 2 months.
670. Obliged, my.
22/7. Item 24.
Appears.
I beg to appear for the, I beg to appear, Your Lordship, for the opposite party.
Yes.
There's a huge delay, and the opposite party is passed away, in fact. And
Have
the
you filed your
reviewers,
affidavit?
I have not filed. I leave it to Your
Party passed
Lordship.
away. Which opposite party?
Opposite party now, the number 1 who's represented through the legal heirs now. So I'm saying there's a huge delay in from the
your
time
objection.
the learned single judges.
You file your objection. Delay is all right, but if it could be explained, we will consider. File your response to the affidavit. Pursuant to the notice in the matter, Mr. A. Patel, learned advocate, has appeared on behalf of the respondent. He submits that he shall be filing his response to the petition, contesting the prayer for condemnation of a huge delay in preferring this appeal. let such an affidavit be filed positively by the next day, we notify up to sometimes in July.
My lord, may I request for a short date, my lord, because the
You could
main
have done it
beneficiary.
today. You were on notice, you could have responded. You could have responded, no?
I could have, my
Anyway,
lord,
June.
obliged, my lord.
19 June.
Obliged.
Item 25.
May I please, my lord?
All are state.
Statement.
Sumitra, there is no objection. You have not filed any objection. So and so. Delay. Delay condoned, application allowed, appeal to be processed. Take her name.
Obliged.
All
24 July.
without just signature from 24.
Obliged.
24/7. Item 26.
Mr. Talukdar, on your insistence, we got it listed.
Right.
But should you have filed this application and should you have mentioned when the order has not yet been uploaded?
Yes, my lord,
I mean, if you show this kind of haste, we'll have to reject such prayers straight away. And you are a very seasoned counsel, Mr. Talukdar. Should you have done that?
my lord, on
Are
earlier,
you aware of that judgment of the Supreme Court which was pronounced only day before yesterday? That in statutory appeals, the prayer cannot be allowed of dispensing with the filing of certified copy? Find out that judgment and tell us. It's only day before yesterday that the Supreme Court has given a judgment.
I'm sorry.
And otherwise also, how do we know what the single judge has done? You did not even wait for the matter to be uploaded.
I'm told, my lord, I am along with the appeal, my lord.
The entire registry, the filing section came running and said that there is so much of pressure from the advocate. I mean, this is not done, no?
In fact, on earlier occasions, my lord, we have done it, my lord. So therefore, my lord, in fact,
Earlier, okay, do you justify this? Then we dismiss this.
no, I'm just, my lord, apprising your lordship. In fact, while preparing,
Division bench must know what are the findings of the single judge, what is there, it has not been uploaded. Aren't you putting the judge and the entire system to sort of a pressure which is not warranted in this matter?
I have only cited the grounds, my lord, on which, my lord, I said that my read petition ought to
How
have
do
been.
we accept it unless we see for ourselves?
No, my lord, I am not, my lord, challenging
See,
anything.
if it were through the office of a youngster,
Okay.
I could have understood, but not from Mr. Talukdar.
I'm sorry, my lord.
The court depends on you advocates.
have
It's
stated-
for your benefit that your submissions are readily accepted by the court for listing, for adjournment, for whatever.
No, I have brought on record, my lord, that it is my lord, not made available by the registry. That fact I have brought on record by the application.
Are we telling you that you have made any wrong statement?
No,
No,
no.
we are not saying that.
No, my lord.
We are on the, I mean, what should I say? Uncalled for urgency shown by you.
I'm sorry. Because, my lord.
Anyway, you.
He was a
lawyers
young-
We understand the lawyers always act on the urgency shown by the clients.
My lord,
but
a
then-
young man
but then-
got the job very difficult. my lord.
Correct. But the urgency shown by your client, I mean, has to be vetted because we go by the urgency shown by the advocate.
Right.
What do we do in this matter?
My lord, I will bring on record by way of an additional affidavit, the certified copy as and when it is made available, my lord. I will also
You
inform.
see all this because otherwise we'll have to say that before it being uploaded, the application has been filed and we reject the application for dispensing with the filing of the certified copy. You want to do that or you don't want to do that? We just adjourn the matter.
Good.
File it to additional evidence. File it in the registry, it will come before us. At least file the photocopy of the judgment.
No, my lord, it is not uploaded. My lord, in fact, I am told
How many,
it is
after uploading it,
not
for
signed.
the purposes of this, otherwise
It is online since yesterday evening,
what?
the judgment.
It has been uploaded.
Uploaded in the kiosk, but not available in the net. In the High Court intranet, it is available. In the kiosk, it is.
System, we are just passing it over. This application at the request of the. We are adjourning it at your request,
My lord.
at the request of legal counsel for the applicant. Class appellant. this matter is adjourned to 23rd of April. We are not keeping it on 20th and 21st. Maybe the bench would not be available there. Or 20th, wherever it was. 20th.
By the time they will appoint anybody.
Sorry, Mr. Kanakai. We have not dismissed your petition. We have not said anything in the order. That's good enough.
Can it be on 23rd, Your Lordship? I'll be out of station.
When?
23rd.
23rd. In the meantime, when you are asking for a date, then you'll have to undertake that nothing shall be done in the meanwhile. Or let it happen 20th. 20th.
I'll be back.
All right. But you know, this indulgence shown to the advocate should be reciprocated.
I'm sorry.
Chalo, yes.
I seek a comment.
All right, all right. You have not done anything wrong, but we are only questioning the propriety.
I'm sorry.
Daily list for admission item 11.
May it please your lordship. Lordship, in this matter is led by Mr. T.J. Mahanta, senior advocate lordship. He's on legs in another court, lordship. I think the matter will pass over the court.
Now, Pradhan,
Lordship, selection for the post of.
you are a BJP member.
Lordship, he was, but before being selected.
Aren't you ready? Argue.
Lordship. Lordship, he's been engaged, lordship. I can argue, but he's been engaged for this matter, lordship.
Take a prayer for adjournment. A prayer for Passover has been made. Passover or adjournment?
Lordship, Passover.
We may not. Today, no Passover.
Lordship,
Prayer for Passover has been made. A prayer for adjournment has been made in this case on account of unavailability of Mr. T.J. Mahanta, learned T.J. Mahanta, Mr. T.J. Mahanta, learned senior advocate who is to address this court. Let this matter come up for consideration on 24th of April. Now, Pradhan dispute coming in appeal.
Well, this matter relates to construction of that Gauhati ring road, Miller.
Yes.
Well, we are not, in principle, we are not against the construction, Miller. We would rather welcome it. But only thing is, Millard, we'll point out, Millard, there are.
You said that on the last day when
Yes.
we were posting it for some other day,
Yes,
that the mandatory forest clearances under Forest Conservation Act has not yet been
yes,
given.
yes.
And
But there are two
it has been issued for filling.
statutory non-conformities. One, the Wildlife Institute of India's suggestion for realignment of the highway just to avoid the forest. That has not been, Millard, adhered to. And secondly, Millard, even though now there is in view of the latest amendment, Millard, because of the amendment now, any road which falls within 100 kilometers from the border does not require, Millard, environment clearance.
What do you have to say, Mr.
However,
Goswami?
In this
In
case,
this slender issue, that does not remain slender otherwise.
I have complete instruction, Mala. It's not that 150 kilometers.
Is it?
No. That's not my case. I say whenever a project falls within 100 kilometers of the,
Correct. Yes,
then Miller environment clearance is not required. That does not mean other forest clearances are not required.
no, that's right. Now you respond immediately.
I have all instructions, Mala. We have complied with everything, Mala. There is no lapse, Mala. If Mala allows me 3 pages, Mala, from here it reveals, Mala.
Why are you panting? You have come running. Yes, let us see what.
This is, Mala, the Forest Conservation Amendment Act.
Where are you reading from?
I've given, Mala.
No, where is your affidavit?
For the first time, notice has not been issued, Mala.
Except notice, you say that every year.
Everything has been complied. Now, Mala, final approval has also been granted, not only in principle, Mala.
What lapse was he pointing out? That's not correct. Factually.
Factually,
Do
Mala.
we record your
Yes,
statement?
Mala.
Do we record your
Yes,
statement?
Mala.
Millard,
There's absolute compliance.
let us see, Millard, how it has been complied with. For example, if a lordship,
No,
let them come to, I'll take 5 minutes.
That's all right. Mr. Chaudhary, because his statement here would not mean anything unless
Yes,
it's on
yes,
paper.
yes.
So let him file an
No,
affidavit.
Millard, what I'm saying is, Millard, regarding clearance of the forest part, that is not comments. They have opened the financial bid. When we filed the petition, financial bid was not opened. Now, Millard, they have opened the financial bid. My only thing is, Millard, the felling of the tree should be stopped until the next day. Let them file their affidavit. But we are not against the project. When you can realign the project.
Suppose they obtain all clearances, then why stop it?
No, my lord, how can they obtain it? They have the, there are two wildlife divisions. They have taken clearance of only one.
They will not fell all trees for the purpose.
Yes, only that much.
We are keeping it on 20th.
Yes,
So we keep it on 23rd.
yes.
All clearance, my lord, have been
Mr.
taken.
Goswami, we understand, we are not stalling the project.
Yes.
For the time being.
And he's also not wanting
Even
it.
our plan is not that.
So suppose in the meantime failed the tree and subsequently found that it is not there.
Can you plant it? Who will take the responsibility, Mr. Goswami?
My instruction is that the tender could not be finalized because of election. So there is no question of felling trees.
Just a minute. Do you remember that case from Maharashtra
Yes.
where the district magistrate permitted it and then he was pulled up, he was sent to jail by a division bench of Supreme Court? It has happened only recently.
Yes, ma'am.
Not even 3 months have passed, or maybe 4 months.
So my instruction, my lord will record my
Mr. Goswami, we will record your statement.
Yes, my lord will record my statement because the tender they have challenged, my lord, felling of tree
That
will not
is
be
not
finalized because of the
questioning
ensuing elections, my lord. So it will not be finalized till election results are on, my lord, because model code of conduct is doing it. My lord is fixing your 23rd.
And file your.
Impugn tender has not yet been finalized, my lord. It is my submission. my lord.
And so make a submission that till election is over, since it is not.
Yes, since fourth of-
Will not fail anything.
Yes.
That's
No,
all.
we will not issue any order, allotment order, my lord.
Why not? Not gonna-
Because otherwise, well, the NG projects and section 41 specific release comes in, my lord.
This public interest litigation aims at protecting the environment. In principle, the petitioners do not question the Gauhati Ring Road project. A massive 121-kilometer highway project costing around 6,000 crores to be built, to be constructed by the National Highways Authority of India. It has been pointed out on behalf of the petitioners that a concession agreement has already been signed for completion of the project, for undertaking and completion of the project, sometimes in April 2025. And the work includes a long bypass road requiring widening of existing roads and construction of a bridge over the Brahmaputra River. As noted above, the necessity for traffic management is not being questioned by the petitioners. But according to them, the route which has been carved out for construction of the bypass allegedly cuts through the Amchang Wildlife Sanctuary and the surrounding eco-sensitive zone. The importance of that road can be assessed from the fact that the area is home to elephants, gibbons, leopards, pangolins, and other animals. The area also connects various other forests and the elephant corridor in the vicinity. it stands admitted in the next paragraph. It stands admitted in this petition that the Standing Committee of the National Board of Wildlife has given the approval for the project. But such approval is conditional, requiring full impact study, no night constructions, etc. The grievance of the petitioners is that those conditions are not being properly followed. The major concern today of the petitioners is that according to the information they have, the mandatory forest clearance under the Forest Conservation Act 1980 has not been granted by the central government. But the DFO Gauhati Wildlife Division has already issued an e-tender for selecting a contractor for felling the trees inside the sanctuary. Such action is dubbed as post haste. And if it goes through, it will cause irreversible damage before any proper scrutiny by the concerned authority. Challenging such contentions in the first instance, Mr. P.N. Goswami, Learned Additional Advocate General, Assam, has submitted that all clearances,
Including forest conservation.
including under Forest Conservation Act 1980, have been obtained. But before a detailed response affidavit is filed, he has made but before a detail, he makes a statement that till the next date,
The impute tender will not be finalized.
the tender shall not be finalized. The tender shall not be finalized. Let the response affidavit be filed positively by the next date, with a copy served in advance to the council for the petitioner.
NGF
Just this matter on 23rd of April.
for disposal on that day.
Huh? But if you show we have nothing, everybody is in favor. We are all in favor. In fact, you don't have state, you have only said.
Yes, ma'am.
Because these projects are very important. Something will have to be done. So clearance has to be taken.
Already taken. I
Because
have the copy,
otherwise
ma'am.
it will be a violation of the Supreme Court judgment. Apart from the fact that it is, you feel really bad to hear that forests are being cut. But then it is for the benefit of the elephants only.
When the PIL was
It is
filed.
not for obtaining wood.
Yes.
By felling trees. They need to have an elevated road. Otherwise, every year even when I was not here in Assam, I used to hear about, these accidents where pachyderms were killed. Assam and Jharkhand. These are very important elephant corridors.
Now railway is also coming up with a elevated corridor.
I have seen that.
Yes.
It's Guwahati only, Mila.
The PL is pending.
We have seen that near Tinsukia for ourselves. In Tinsukia, there is a
Gibbon.
Gibbon.
Not Jorad. In Jorad. What is that?
Gibbon Wildlife Sanctuary.
No, there's a special name for it.
Dibru Soikwa.
Not the Jorhat sanctuary.
Jorad was sanctuary where it's a monogamous
Yes.
animal.
Hollow Gibbon.
Hollow Gibbon.
Wildlife Sanctuary's name is also
Just
given.
to the side of it, that's a railway track going.
Yes. When the PIL was filed, there was in principle approval. Now, final approval under
Anyway,
forest.
because this is for the benefit of elephants, we are not stopping it. You say that it shall not be finalized and we have given a short.
Yes.
Be clear.
Diplomats.
Item 13.
Yes.
May it please. So this is an appeal against the interim judgment in order dated 2/12/2025, passed by the learned single judge in WPC number 2092 of 2021, whereby the learned single judge has directed to regularize the casual employees engaged in the activity.
1 second. You have to respond.
Hello.
You have to respond.
Well, today my name was not shown, my lord. In fact, in this case, I have not filed Wakalatnama also. There was a connected matter, my lord. Because two petitions, my lord, for the respondents.
Private respondent.
2 to 7.
For the private respondent.
Private respondent. These are otherwise, my lord, covered by this Dharam Singh and Zagbo case, my lord.
No, don't take that simplistic stand.
My lord.
There are two things. The Central Tribunal, Central Labor Court, Labor Tribunal, rejected their claim.
My lord.
Rejected your claim.
My lord.
And whether a writ petition was maintainable, that is one question. And then the entire award is set aside, taking into account something which was done in 1995.
20.
Because neither here nor there. You appear for all the respondents.
My lord.
Some other matters are completely.
In fact, the aspect of bonus was also dealt with in the same order. In that matter, lordship has fixed on 15th of June.
Out of the same.
Same
Out of the common rules.
Can you give us the details?
Yes, my lord.
Why do you people keep quiet and only when it is questioned? We can't strain our memory so much.
I was supposed to.
So you should have said that in the
Lordship has not
beginning.
allowed you.
You should have passed some order.
Madam, what connected case, there was a delay of 48 days that was condoned by your lordship, order dated 6/4/2026, day before yesterday, my lord. And the main rate appeal was directed to be registered, the rate appeal, and then to list it on 16/5.
Can you give us the number?
Yes, my lord. It is rate appeal filing number is 1882 of 2026.
How do we get the number? Original, not filing number.
This is filing number.
Let this appeal be listed along with writ appeal number so and so, which is slated to be listed also.
15/6.
You will have to explain that whether single judge had the jurisdiction to deal with this.
Yes, ma'am.
Item 14.
Obliged, ma'am.
Yes, Mr. Medi.
Page 19 of the about this get, madam.
Page 19.
1990, madam.
And
9-0.
and relevant portion, my lord,
What is the fact of the case? Relevant portion is straight away you will come.
Yes.
What was the prayer made by the applicant?
my lord, applicant, my lord, here, my lord, the EWS, my lord, the certificate was not filed in proper time, my lord. So at that time, my lord, as per
Where
his
is the difficulty? You have given it.
my lord, yes,
Delayed or not, delayed or on time, but that was accepted to be correct. So
my lord, it was,
why should it not relate back to the period?
My lord,
Yeah.
my lord, they submitted in 2024.
Let me, you accepted it.
Yes, my lord, as per my lord, then my lord, so for seniority is concerned, my lord, and my lord, others benefit, my lord, national benefit, that part, my lord.
Why not?
Because my
Why
lord,
should it not be given to it?
it is not from not our fault, my lord, it is his fault, my lord.
Doesn't matter. It is not for a big period. Anyway, let notice the issue. I will go. The petitioner, like Director General of Postal Service, has questioned the order dated 6/1/2025, passed by the Central Administrative Tribunal, Principal Bench, New Delhi, in original application number 3990/2024. Next, the respondent had applied for SSC combined graduate level examination conducted in the year 2022 as an economically weaker section against an economically weaker section quota. He passed all the levels of examination and was provisionally allotted the post of sorting assistant in RMS S division. RMS then within apostrophe, not apostrophe, within quotes, S division, Silchar. This appointment was under the EWS category. But it was later found out that the respondent had not submitted the necessary and valid income and asset certificate issued on or before the crucial date, which in this case was 8/10/2020, the closing date for receipt of online applications. The certificate had to be based on the relevant financial year income, which in this case had to be for financial year 2021-22, which would have been valid for the year 2022-23. It is the case of the petitioner that the required EWS certificate was not produced by the respondent on 9/10/2023, on the date when physical verification of the documents were made. The respondent had submitted an affidavit regarding his entitlement. Nonetheless, he was given an extension to furnish the valid certificate, but the same was not furnished till 31/1/2024. On that day, a certificate issued on 31/2024 was furnished by the respondent. For such delayed submission of the entitlement EWS certificate for his entitlement, the appointment of the respondent was cancelled, which was This cancellation was questioned by the respondent. But later, with the interference of,
Candidate sir was cancelled, my lord, appointment.
huh?
Candidate sir was cancelled.
With the,
My lord, candidate sir was cancelled, appointment was not.
the candidature of the petitioner was cancelled. The candidature of the petitioner, of the respondent was cancelled. However, with the later intervention of the tribunal at principal bench, the tribunal at the principal bench, the certificate furnished by the respondent was verified and was found to be genuine. The respondent was given a provisional appointment letter. What the petitioner questions in the impugned order dated 6/1/2025 is the direction to grant the respondent all notional benefits as per law, including seniority, pay fixation at par with his juniors, or perhaps batchmates within 8 weeks. Mr. Mehdi, learned CGC submits that there was no delay on the part of the appointing authority. Stop. The provisional appointment, the delay was only caused because the certificate entitling the respondent to avail the EWS quota was not submitted by him, despite a long extension of time to him to submit such certificate. Under such circumstances, notional benefits like backdated seniority or pay parity ought not to have been given. The delayed appointment was only because of the respondent's initial non-compliance, which led to cancellation of his candidature. But later, with the intervention of the tribunal, the appointment was given after verifying the correctness, after verifying the genuineness of the document in question. This, Mr. Mehdi argues, does not entitle retrospective benefits to the respondent. Let notice be issued. We are not staying because we are inclined to dismiss it.
Earlier court also directed to consider it.
They are not staying. You pass, sir, if the order is otherwise, you
Madam,
comply with the order, otherwise there will be contempt petition.
earlier court also
You comply
consider
with the order, any notional benefit, any monetary benefit will be adjusted later in case you succeed. We are not inclined. If you want any stay, we dismiss it now. If you want a notice, we are issuing notice.
Well, that observation may be
Nothing.
Only when earlier.
We are inclined to dismiss it straight away. What is this?
Well, earlier also, when
Are you a model employer? No, you are not.
Yes, madam, yes. Because madam, there is.
They be happy with your
Yes, madam, yes.
Tell carefully. Let notice be issued to the respondent on steps being taken by the petitioner within a period of 2 weeks, both modes, 3 weeks, both modes returnable, July. No stay. You can no stay. Should we say no stay?
18 July. Item 15.
My lord.
Yes.
My lord, this PIL against the fatal accident that commenced by the dumper truck, my lord. My lord, in the state, there is no regulation and
Yeah, California. Where is the statistics which says that maximum deaths have caused road crashes because of the dumpers? Dumpers are trucks.
my lord,
You're not made out a case, Mr. Bashar.
my
Give
lord,
us some more statistics, we will ask them.
my lord,
Look,
my lord,
We
human
are-
life can be saved.
Mr. Bashar,
My
I'm
lord.
denying that. Try and understand what is our objection.
My lord.
You have not given us sufficient statistics for us to interfere and ask Mr.
My lord,
Sharma.
I'll file additional evidence.
Mr. Bashar, after some argument, seeks time to provide additional information in support of the grounds on which this PIL, this PIL has been filed. Take up. The petitioner in this case is a young law student who has alleged that most of the accidents on road are because of unregulated flying of dumper trucks, which are also called tipping trucks, T-I-P-P-I, tipping trucks. His contention is that these vehicles have huge blind spots because of their size and the position at which a driver sits in such vehicles. A driver sits in that vehicle, in such a vehicle, making it impossible for him to see smaller vehicles around. The lament of the petitioner is that there are no strict rules regarding when and where such vehicles could be permitted to fly on public roads. He has also questioned the permission to use such vehicles without the vehicle having modern safety gadgets like cameras, 360 degrees cameras, blind spot sensors,
Speed controller.
modern brake systems, or perhaps speed limiters. Speed limiters. Stuff. That is equally no enforcement by police or transport authorities. However, on being questioned about the reason to file this application, however, on being questioned whether the statement regarding more number of deaths by such dumping trucks being true, and also the source of information for making such a statement, Mr. Bashar contends that further statistics shall be provided by way of an additional re-notify of July, August,
My lord, July, my lord.
29 July.
Oblige.
Item 17.
Yes, what is the matter?
My lord,
If he wants to go to another place, why you may be having paucity of staff. How does it make a difference?
not before that.
Suppose my court master says that you have paucity of staff, so that is your problem. I'm getting a better offer somewhere in Odisha. He's going. How do we stop him?
No, my lord, not only for the prosecution, there is the, my lord, kindly see the order of the, here, my lord, the, landed code below, my lord, in page number 192, my lord, kindly see. Page number 192. Last page, no. Paragraph 11, my lord.
After our judgment, what is your?
No, that is, I'm coming to that, my lord. That is, yes, my lord. I'm coming to that, my lord.
Yes.
My lord, here, my lord, in view, paragraph number 11 in 192, my lord. In view of the fact that railway authority did
I
not
don't have paragraph number 11.
192 last page, my lord.
The numbering is not correct and the page is missing. Again. Hmm?
Yes,
You don't say anything, you file it for
Yes.
registry. How are they done it?
yes,
Supply a copy of that order.
yes, my lord.
2 copies of that order.
Yes.
Unfortunately, I in my copy there is an order.
Sorry, my lord. Sorry.
Again, as prayed for on behalf of the petitioner by Mrs. A. Graham, the matter is adjourned. We are not inclined to interfere, let me tell you. We will hear your arguments.
Yes, my lord.
It may.
Fix
Mr.
on my
Das, you are appealing for who?
For the respondents, my lord. It's absolutely covered by your lordship's order, my lord. Absolutely covered.
lord. My lord. I'll satisfy on that, my lord.
Have you got that? Have you got that appointment?
My
You
lord,
left the railways, you joined some grade 7.
the Oil India authorities, my lord, we're supposed to cancel my candidature because of this. And we filed a writ petition. This honorable court, my lord, protected us from cancellation of candidature, my lord. Thereafter, they rejected me. My lord, this boy has been, my lord, subjected to so much of litigation, my lord. It's really unfortunate, my lord.
Anyway, did you get your appointment or not?
No, till date. No.
It's a short time. We'll give a short time.
Yes.
Yes, my lord.
It should-
Immediately after.
Let my senior correct, my lord. Let my senior correct the. Let my senior correct the pages.
Yes, sir.
23rd.
23rd. Must
Fine.
bless, man.
Item 22.
Highly obliged. Thank you.
In this PI lordship, some very serious allegations were leveled against the authority lordship as well as the contractor lordship. On last day, lordship directed us to file our affidavit lordship. We have already communicated. But today, lordship, I'm praying for some accommodation. Lordship, I'm praying for some more time, lordship. We want to file a detailed affidavit. Lordship.
Mr. Nayak. Additional advocate. Mr. Nayak, learned additional advocate general. Submits that all necessary information for filing counter affidavit has been collated. And the response and the counter affidavit shall be filed positively by the next page. Re-notify.
Lordship, in the meantime, appearance of the private respondents should also be made clear.
पहले आप अपना जवाब दीजिए.
Lordship.
29 July.
Now,
29.
in our eyes, you are the person, you are the nodal person. So you tell us, he satisfy us, it's all right. Otherwise, we'll turn him down. If you're not able to satisfy, we will question everybody.
Lordship,
May
understood.
I pray for a short date, 29th of July,
Yes, sir.
in the month of June,
June,
June or May, Lordship,
July.
29th of July.
Let them, in the meantime, they will do something.
Obliged.
Item 27. Supplementary list.
May I do the watches? Lord,
Just give us a minute, Mr. Manta.
yes.
Mr. Mahanta, you work for some contractor and you cite that as an experience. You show your bid capacity because of that. But aren't the employers, aren't the tender issuing authority required to know that whether there was any privity of contract between you and the main contractor on the basis of which you claim experience?
Yes.
So this is one, you don't have that. You rely upon, just a minute, let us tell you what we have found out
Yeah,
from,
yes.
from the order. Let us tell you, then you respond.
Yes.
Now, you rely on some certificate issued by an engineer, executive engineer, one. So they have the leeway whether to accept it or not to accept it, number one. Number two, LOI and LOA are two different things. The work order is something different. It's letter of intent. And they did not want to do it without taking performance guarantee because you had offered a very low price. Now, for assessing that, they wanted you to give supporting documents for your performance bid, additional performance security. They found that no, you have worked for somebody without there being any contract, as if a private worker who does for a small work. That's the reason. So, therefore, we are not, Mr. Monda, prima facie, we find that refusal to grant interim relief was justified even on the main grounds. You don't have a very strong ground. Has the contract been concluded with somebody?
Now they have gone ahead with it. Not yet done.
I
Not
think you can go before the learned single judge and have the whole matter decided, because we are not interfering with this refusal to interfere at the preliminary stage.
No, my lord, I'm grateful for the lordship's mind already expressed.
Naturally, because the moment these are very, very tentative versions.
Yes.
You tell us, we will switch.
Now, my lord, firstly, I will address the point. What is the implication of the LOI? Lordship has rightly pointed out, LOI in all cases may not be, it just simply intention has been expressed.
No concluded contract.
No concluded contract. But here it is different. It says definitely that unless you accept it within the time LOI, it amounts to an LOA and you forfeit your EMD, earnest money deposit. It's specific, kindly see. Page 412 in the second volume. The conditions of that contract.
.401.
412.
Then we agree. It was
412.
very akin to almost issuance of a work order. Agree. But then before they could fall in the trap, they wanted you to give additional guarantee.
They have taken adequate care by taking security from me. They asked me, you furnish additional security. I submitted. Sorry?
That supporting document with
Well, question that Lordships has raised the question whether I can utilize my experience while I was working as a subcontractor or under any other contractor.
No,
The authority,
there is no bar.
Yes,
But then there should be a document suggesting that you are validly sublet the contract.
Malad, so far, the subletting is concerned with the contractor and me, there was no difficulty. But what learned single judge or lordship has pointed out, that the privity of contract between me and the contractor
Yes.
and the certificate granted by the authority itself that he has successfully completed the work and they are satisfied. So my experience in doing work, they have not raised this issue there. Therefore, I say, my lord, when they have found that my bid is responsive, so for a technical bid is
Mr.
concerned,
Mohan, that you can't conflate, your client cannot be permitted to conflate this issue. That the work which you conducted on behalf of some contractor as a subcontractor, the work was finished and payments were made. Correct. The engineer also certifies that you did the work, but this was under shadow. Who will accept it? Mr. Goswami is not going to burn his fingers as an employee of the state government, which will accept your contentions as correct. Now, where is the paper?
now the certificates were placed. Those certificates were issued by the chief executive officers. Those are placed on record. Court
Now,
has
how
seen
do you
that.
say, how do you say that they are proceeding ahead?
Mallam,
How do you say that they are proceeding ahead?
because they have floated immediately on the very next day, they have floated the first tender.
What is the next date fixed in the matter before the learned single judge?
Next day. In the order itself, Malad, it is located.
Any decision shall be subject to the outcome of this.
Lordship may I suggest, here is in Maharash's Pro submission, that here is a strong case to be decided. Until then, at least it may be three weeks, they should stop going ahead further. Whether my rights, I have a right
Mr.
to.
Manta, I give you another option. I give you another passage.
Well,
You don't press this application, we give you the liberty to file an application file an IA before the learned single judge for preponing the date, or in the alternative, making any decision by the respondents subject to the outcome of the petition. That's all.
Sorry, when can you file the affidavit?
We have already filed, madam.
They have filed an affidavit.
No.
It was considered.
They came up without notice and filed affidavit.
Yes, madam. PDP has taken note of, madam.
So you make an application. Mr. Mahanta, we are very clear in our mind. This latitude has to be given to the tender issuing authority. Last moment before the work order was issued, it can be rescinded. And they have, the reason may be good, the reason may not be as good.
Yes.
But the question is that they have the authority because it will not be akin to, despite the fact that you gave the performance guarantee.
Milad,
The question is that your performance guarantee in relation to your bid capacity was not found to be correct, according to them.
according.
Now, should they not be allowed that leeway to decide which is a better person to give the contract to? Number one. Therefore, we are not interfering. Number two, we give you a passage, a safe passage from here without disclosing our intentions. You don't press this application. After some arguments, you withdraw to enable you to file an interlocutory application before the learned single judge for two reliefs. For preponing the matter, for fixing an early date to which he will not disagree, and in the alternative, making an observation that any decision taken by the authorities with respect to settling the contract with a third party would be subject to the outcome of it. That's all.
Milad,
We will, if we had heard it, in fact, if you press this, we ask him to file counter affidavit, we can decide, we can take the matter from the learned single judge and we decide, because we are absolutely clear that in these matters, like a private party, the choice lies with the
Lordship will also kindly appreciate, and Lordship knows it, that they cannot utilize that power arbitrarily.
No.
They will have to.
They have to. So reason which they have given appeals to us.
That is unfounded totally. My case is this. This is totally unfounded
The
job.
difficulty, Mr. Monta, is that this is appealing to us for the reason that, you see, some shadow contractor, you can say you can get that certificate from anybody. Private contractor, his certificate I will not accept it. And you have not even given that.
But My lord, the APDC had accepted those certificates. They found my.
In a different transaction where payments
True,
will be
true.
made.
My lord, only thing is to see my experience. Now the question is whether
Mr.
the.
Mahanta, the safe passage is good for you.
My lord,
Take
lordship,
that.
my lord, no, my lord, lordship has, until then at least they should not go ahead with.
What is the last date of submission of this?
Technical fees have been opened, my
Huh?
lord. Technical fees have also been opened.
So they should not go ahead with
In that case, my lord,
until then.
We can't guarantee that. We are giving you this permission.
No,
They are
because
not
of the
going-
holidays.
They are not going to do it in Bihu. You file an application on 20th before the learned single judge obtain an order.
My lord, because of these holidays, Bihu holiday,
They're not going to say no.
they should not go ahead with. At least God say protect me till that day. Otherwise, if you go ahead and finish it,
They will
what
not.
remains will.
They,
For
in
me.
the power project, they will not. I don't think it's not practical because the one, there is election till 9th. Two is all Bihu. We
True.
give you the permission, file an application, keep the
Well,
idea,
I'll
keep the
do
idea ready.
I will do it on the very opening day. But meanwhile, they should not. That is my apprehension. Because the speed at
That
which
guarantee-
they are proceeding.
Mr. Goswami, we have seen him. We have seen Mr. Goswami in other matters where situation comes to this pass. He always gives an undertaking that we will not do this.
Malaji,
But here he is not willing.
Malaji, yeah, because can you see, Malaji,
Section 41
at what
specifically.
speed they are proceeding. They got enough time when my technical bid was evaluated and accepted.
In any case, even if that,
Thereafter,
just a minute, Mr. Monta, in any case, even if the single judge has not decided it, has not said it in so many words, any decision by the single judge would govern the outcome. And by that time, I'm sure, even on the original date fixed in May, the work would not start. So it can always change.
all of that for even then to keep the balance, the position intact.
The Mr. Mantha, the difficulty is that with that kind of an observation by us, the balance will tilt slightly in your
No,
favor.
no, Malak.
Which we are
Lordship
not-
will simply, Lordship will simply say that I will file an application, court will consider
This is
it.
good enough.
But until then,
This is good enough indication that after some arguments, we permitted you to go before the single judge.
until 20th, at least reopening day.
Don't worry for 9-5.
Okay, Malak, I want that much from your Lordship so that I can take the course.
We will record, then in that case, we'll have to record your submission and reject it.
Malak,
That would again tilt. in
Malak,
favor of them.
Lordship will appreciate. I have come before your Lordship. Lordship retains the discretion to allow or reject.
No.
I have the right to argue.
No,
That
no,
is
no.
always there.
We
But
will-
Lordship is trying to give me some
I'm
relief.
trying to give you relief
Yes, I accept
to
it.
the extent that it is possible for us.
Malad, without entering into deep into the matter, I take your Lordship's view. But then I only ask for that until then, they should not hurry up. These things have been hurried up.
Now, let me give you another reason. This 1 week time,
Yes.
your apprehension is unfounded that
Because
anything
Bihu.
will happen.
Because of the
Election plus Bihu.
true. But Lordship, it is
Don't have an
difficult.
order.
It is difficult.
Tell us we are going to pass an order and we'll pass such an order that it will be loaded in your favor.
I leave it to your Lordship.
Without
I leave it to your Lordship. Malad.
I think we should eschew from writing anything on merit certificate. Because that
Yes,
might
yes,
that
better.
might tilt
Yes.
in Mr. Goswami's favor. So let us say after some argument. Take this appeal. We have heard Mr. Mahanta, learned senior advocate for the appellant slash investors with power Infracon LLP and others appellants. The present appeal is directed against the order dated 27/3/2026, passed in WPC number 1632 of 2026, whereby the learned single judge has refused to grant interim relief prayed for by the appellant, restraining the respondents from continuing with a fresh tender process which the appellants claim has made their writ petition infractuous. The appellant, after having been found technically qualified and crossing the muster of financial evaluation, was declared L1. He was issued a letter of intent, which according to the appellants was accepted, and the appellants were permitted to submit their requisite performance guarantee and additional performance guarantee. It appears that later, while evaluating the bid capacity of the appellant, which was necessitated because of abnormally low price offered by the appellant, it was found that the experience certificate furnished by the appellant was in its capacity as a subcontractor, without there being capacity as a subcontractor without there being any written contract or agreement between the contractor and subcontractor.
And if I may just put up, they have not said in so many words, they simply say, my financial bid is formed. This is the ground.
Therefore, we said, no, not a word we should write, because this is what you have tried to explain.
No, Malad.
You have tried to explain.
No, it is from their own order.
Anyway,
From their own order. They say, my financial bid is formed. Never on this issue.
The bid capacity of the appellant was not found to be up to the mark. The primary contention of the appellants is that this exercise ought not to have been undertaken by the respondents at such a belated stage, when the appellant was permitted to, when the appellant was declared L1 after thorough evaluation of his tender papers, and was permitted to deposit requisite performance guarantee and additional performance guarantee. The apprehension of the appellant was that either another person in the fray would be selected, or the respondents would go for a fresh tender. This was questioned by the appellants before the learned single judge, who issued notice to the respondents but declined to grant any interim relief. The matter is directed to be listed before the learned single judge for final consideration on 6/5/2026. Next week. After some arguments, Mr. Mahanta, learned senior advocate, seeks permission to withdraw this appeal, with the liberty to him to file an interlocutory application before the learned single judge, with a prayer for fixing an early date, or in the alternative, observing that any decision of the respondents in that regard would be subject to the outcome of the writ petition preferred by him. With such leave, the present appeal is permitted to be withdrawn. Disposed of as withdrawn, we should say disposed of as withdrawn with the liberty of forces. This is the maximum that we could give you.
Deeply obliged, my lord. That from my side, you well wishes to your lordship.
And
And that is a gift
also
for
seek the blessings of the elders and good wishes to all others.
deeply.
I think all would be junior to me in age, except Mr. Manta.
Item 28.
We have done some homework
My lord.
and we have incorporated as far as possible every argument of both sides. It's not necessary to be read. We will only say, we will pass it on to you people. Yesterday, what argument was made, that also I have incorporated. Article 14, we have incorporated. But we have our own views in this matter. We'll read few paragraphs. At the outset, it ought to be clarified that a COI is not equivalent to Sikkim subject status. It is neither a substitute for inclusion in the Sikkim subjects register nor a determinant of citizenship. The distinction between the status and administrative recognition for a limited purpose, we are of the view, is very crucial. In Surinder Sharma so-and-so, the employment-related classifications rooted in Sikkim historical context have already received the judicial imprimatur. Now, the arguments based on Article 14 and 16 of the Constitution need be analyzed and evaluated. It needs no reiteration that for a classification to be permissible, there must be an intelligible differential between the separately classified people and the rational nexus on which the classification with the objects ought to be achieved. Applying that principle, so-and-so, non-Sikkimese, this, that, we have said, this can be viewed from with respect to grandson. The communication of 2006 clarifying that the benefits will not extend to subsequent generations indefinitely and perhaps infinitely cannot be said to be arbitrary. The benefits tied to a historical advantage or disadvantage or classification has to be reasonably limited. The extension of benefits to third generation would dilute the original basis of classification. The state is definitely entitled to draw a line, provided it is not manifestly arbitrary. This aspect can be viewed from another angle as well. And then we have quoted section 8 of the subject regulation 8 of 1961 regulation. And then we say that that time the king had permitted only the wife and the minor children. And so and so. In present case, such clarificatory note not extending so this is the same thing. We must note in international comparative jurisprudence also, the principle that a classification must remain tied to its objectives and must not expand beyond its justificatory basis finds resonance. The apprehension of the respondents that they'll be treated as non-locals is unfounded and all that. In fact, without any concession from any of the parties, in fact, it would be more appropriate for the respondents to pursue their respective claims before the central government committee for their names to be included in the Sikkim subjects register, which for some reason or the other was left out. Viewed thus, we are left with no option but to affirm the competence of the state and its instrumentalities in coming out with such clarificatory notifications, limiting the utility of the COI for the purpose of employment only and for no other purpose, and to declare that the interference by the learned single judge in WP number so-and-so was not justified. The order accordingly, the judgment impugned is thus set aside, the writ appeal stands disposed of, no order is passed.
Deeply obliged.
So deeply obliged.
As far as possible, we have incorporated all your arguments.
My lord.
So grateful.
So this is, once it is decided, it can always be tested.
Yes, yes.
I agree.
Pleasure and privilege.
No, and happy Bihu to all of you.
Thank you, my lord.
Bihu, I'm told in Assam, they blessings are sought from
Yes.
elders.
Yes, yes.
So I think only 2 of you would qualify for giving blessings to me. Rest all can take it from me. Only Mr. Chaudhary who would
Yes.
take it,
Yes, yes, yes. Certainly, my lord.
and Mr.
He is
Dave.
1 year senior to me.
So rest all, my good wishes and God bless.
So deeply obliged.
Wishes and happy Bihu, my lord.
Happy